Okay, the third paragraph.
Same felonies, Judge, first degree and second degree.
I agree.
Thank you for your patience while I'm editing. Okay, then a firearm.
Judge, before we continue, I would also add on, with respect to the title as well as the first paragraph, I think great bodily harm can be deleted. It's really not a factual dispute that there was a death, not just great bodily harm. So.
Defense?
I agree.
Okay, so it'll just say possession of a firearm and discharge? Causing death?
Causing death.
And the same thing throughout, correct?
Okay, so let me just take a moment to find everywhere where that's written. Give me a moment because I want to go over it slowly to make sure I'm doing it correctly. Okay. I only really see it in the title in the first paragraph.
Right. I think
Okay. So then let's go to a firearm is legally defined. Let me go back up and steal the definition as previously defined.
I think that was under shooting, throwing a deadly missile.
I believe so as well. So we'll take that language and that is done. Let's continue on to the next paragraph. Give A or B or both as applicable.
I think A is the only one
Correct.
Defense? Okay.
applicable.
So I'll just make that one sentence. Okay, B will be taken out. Now will take us to 3.3A. And before we get there, let's say any other changes, alterations to 3.3D at this time?
No.
No.
Okay. Then let us go to 3.3A, aggravation of a felony by carrying a firearm. And I am, do you all have that one?
Yes.
Okay. I need to change the name in there. Okay, any alterations or changes by the state?
Yes, Judge, I think it should be all three of the homicide offenses, first, second, and manslaughter would also be applicable.
Okay. Defense?
I agree.
Just give me a moment. Try to cut and paste this to make my life easier. So it'll read first-degree murder, comma, second-degree murder, or manslaughter.
Right.
Or manslaughter, comma, and you also find beyond a reasonable doubt.
So is the
Then
court
the
gonna-
last paragraph,
Is the court going to delete the language as a lesser included offense?
yes, all of that's going to be gone. Then you should find him guilty of, same, first-degree murder with a firearm, second-degree murder with a firearm, or manslaughter with a firearm, correct?
Correct.
And then, in the last paragraph, it will simply read, if you find he committed first-degree murder, second-degree murder, or manslaughter. To cut and paste. But you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of first-degree murder, second-degree murder, or manslaughter.
Correct.
Okay. Defense, are you in agreement?
Yes. Also, under the firearm definition, just want to make sure that we're using the definition that we used previously, that it excludes.
Well, I just was going to shorthand it and say a firearm is legally defined as, previously defined in these instructions. If you want me to read it again, I'm happy to do it.
No, that's fine. I just want to make sure that the machine gun and this and muffler and all that
I'm
stuff.
taking that out. But State, are you okay with
Yes.
making it short?
Referring to the previous definitions?
Yes. Okay. So, the court believes that 3.3A and 3.3D should go after the self-defense 3.6F justifiable use of deadly force instruction. But I will hear suggestions from both state and defense as far as placement within the instructions themselves.
That's fine with the state.
That's fine, Your Honor.
Just give me a moment right now to get the aggravated battery instruction. Do you have a jury instruction number for that?
8.4.
8.4? Thank you. Okay, now in the instruction, to prove the crime of aggravated battery, if you want to look in your books, 8.4, it says, the state must prove the following two elements beyond a reasonable doubt, but obviously this is a defense. This isn't being charged, read to them. So,
I don't think there should be any words like the defense must prove.
right, no, I agree. I think it should say the
I think it
crime
should,
of aggravated battery is
Exactly, it's
Defined
defined as follows.
is defined as follows.
something like that. Correct. There's a crime scene.
Okay, paragraph 1, Derek Medina intentionally touched or struck victim against his will or intentionally caused bodily harm to victim. A and B.
Medina?
It would be.
Oh, excuse me, I
Jennifer.
apologize. Jennifer Alfonso. So defense, are you requesting A or B, or both?
On paragraph 2 you're talking about?
Paragraph 1 of aggravated battery. There's two elections, one
Okay.
A or B, or both.
I guess I'm looking at the wrong instruction here, but it should say Jennifer Alfonso intentionally touched or struck Derek Medina against his will and intentionally caused bodily harm to Derek Medina.
It would be or, but, State?
They want both, they can have both.
Okay, how about 2A and B?
I would ask for both with great bodily harm on A and use deadly weapon on B.
State?
Fine.
So the definition of deadly weapon will be introduced. Okay, at this time, any other changes or alterations to the jury instructions?
No, Your Honor.
No.
Okay, I'm going to send them to Nikki now. She's going to make copies for us so you all can see the changes. The editing skills are these days. Okay, so let's take up our next issue.
You want to go to verdict forms, Judge, or no?
Oh, I apologize, yes. Do you all have the verdict forms?
I do.
Let's look at, let me just pull them up for a moment. Okay, so it's a verdict form count 1. think we need to do A, B, and C in there, don't we? For count
Yes,
one- for
Judge,
one?
there actually should be 4 choices because if you recall, there's 2 separate instructions applicable to the firearm. There's the carry, display, use, threaten to use a firearm, and then there's actually possess the firearm, which it actually should, for number A, I think it should read actually possess the firearm or did not actually possess a firearm. That's how the jury instruction language tracks.
Defense, would you like to be heard?
That's fine.
Now, should these options, A, B, and C, also be for count one? What is the state's position on that?
Judge, yes, we would like them applicable, or we would like the jury instructed as to, just as you have it, if they find guilty of either or, that they have to make the findings of whether, first, we think the first paragraph should be the defendant carried, displayed, used, threatened, or attempted to use a firearm, or the defendant did not carry, display, used a firearm. That's 3.6D, I think, from our instructions.
Fine, Judge.
3.6A, excuse me.
Okay, so A will be, see the best way for me to do this from here.
Judge, may I just?
Okay. So if you check 1 or 2, I guess the way I initially had it was, but I think it may be confusing. If you read it, it says if you've checked number 1 or number 2, you must check any one of the following. But I think what we perhaps should do is break it up even more and just say if you check number 1, and then put the elections after number 1, which is the found guilty of first-degree murder, and then number 2, say if you check number 2, you must make the following findings.
That's fine, Judge.
Defense, are you okay with that?
Fine.
Okay. And that way it's a little bit less confusing. Okay, so with that being said, you want the first election to say the defendant.
I would suggest that the first selection track the language of what we instruct on 3.6A, aggravation of a felony, which is
So read it to me.
the defendant carried, displayed, used, threatened to use, or attempted to use a firearm.
Say it slowly. I'm not as fast as
He
Van
carried,
displayed,
used,
threatened to
use, or attempted to use a firearm.
use a firearm. And then the second one will be did not do
Did
those
not.
things.
Right, correct.
Okay. Other than a small typo, I think I've got it. Okay. That change will also be made under second-degree murder. Any other changes or alterations suggested as to verdict form count 1?
Just that, did the court add the language actually possessed a firearm?
Yes, I have.
Okay. Then no.
None from the defense, Your Honor.
Let me just make it pretty. Deborah does not like to read ugly verdict forms. Has to be pretty. It's crazy. Freeze. Wash my hands. Okay, let's take up our other issues.
Manslaughter, Judge?
Yes. Okay. Then we have manslaughter.
Right, Judge, I think the manslaughter language, 1020 life is not applicable to manslaughter, so we don't need all the possessed discharge, but we do need the same language as carry, display, used a firearm, because that can
In lieu of what we have there? Is that your recommendation?
Correct, Judge. Again, to track the language of the instruction, it should read carry, displayed, used, etc., a
Okay.
firearm.
Defense?
I agree.
Okay. Let's turn that in. Got another one for me? I'm going to ask you to make these pretty for me. Okay, any other changes on verdict form 1?
None from the state.
So you're going to administer
I'm sorry, Your Honor, what are we looking at?
Still number 1. Count 1. Any more
No further
changes?
changes, Your Honor.
Okay, let's look at verdict count 2. Any objection or alterations?
No.
No.
Okay, I got one right. That's good for me. Okay, how about count 3?
No objection.
You're 2 for 3, Your Honor.
Listen, I'll take those odds. Okay, so Nikki's going to hand out 2 for each side. She's already gotten those changes done, and she is going to check my work. Nikki, I'm going to send you this.
Are these in order also, Judge, of how you're going to read them?
I believe so. Okay. If they're not, I'm going to put the onus on you all to correct my work. Okay, Nikki, come here. Okay. I just want to show them to you. There's like, it may be, this will have to turn to C and make sure all of these numbers are like number 2. And make sure they're all like paginated, that all the same things are bolded. Really only number 1 is what you have to look at, number 2 and 3. I just, fine. Okay, and then once you've done that, send it back to me when you print it. Okay, I sent it to you. Okay, so I'll give you all time to be able to look at the changes in the jury form and the verdict form in just a moment. Let's take up our other issue because our jurors are going to be back in an hour and 15 minutes. Okay, so that will take us to the issue related to the state's motion in limine this morning on Mr., is it Schumacher or Shoemaker?
Schumacher, Judge.
Mr. Schumacher's testimony. Okay?
Okay, so, Judge, I just had the pleasure of being able to read the transcript of Mr. Schumacher's deposition, and I can't think of a more thoroughly insightful view as to what our position is and contradicts the government's position. Let me tell you why. Throughout the pendency of the case, the prosecution has gone to great lengths to suggest or elicit through testimony, even over our objection, putting the mannequin in a kneeled position right in front of the jury as dowels were inserted into the mannequin. They're clearly suggesting, both tangibly in front of the court and through testimony, that Jennifer Alfonso was in a cowering down position. Mr. Schumacher, through his work and through his observance of the shadows, clearly dictates that both shadows were in a standing position. And he doesn't do this just based on the video. Judge, he went to the crime scene. He went to the crime scene, went into the kitchen, evaluated the kitchen, and then him personally, and it's in the transcripts of the deposition, goes and mimics where somebody would be to cast the shadows that are consistent with what's on the video. So with regards to whether or not it's probative or prejudicial, it's 1,000,000% probative in terms of just that one issue. Furthermore, he's able to educate the jury as to, based on the shadows where the people were standing. You said, well, he can't say who's who. If you look at page 39, line 22. I'm sorry, we'll start with page 39, line 19. I believe Ms. Klein asks, what do you think is her shadow, correct? You can't be 100% sure. Mr. Padilla objects. The witness, in my opinion, I don't see how it can be Derek's. If you play it in real time, there's no way for him to leave his shoulder at the edge of the video and at the same time be down there leaving his shadow on the counter. So last time you see a shadow down there is 7:33 and 33 seconds, which means to leave a shadow, you have to be standing up at that time. That goes exactly part and parcel with what our defense is. So the issue as to its relevance and whether or not it's prejudicial versus probative, Judge, they have presented blood splatter experts. They have presented other criminalists. They have presented their medical examiner, all of which suggest that she was crouching or cowering. That was the language that Detective Grossman used, cowering. That's the language they used in their opening. The dummy that they put in front of the jury for Emma Lou's direct and cross-examination, all in a position suggestive to the jurors that Jennifer Alfonso was in that position. This expert rebuts it with tangible evidence.
So let's talk about the Daubert standard. How do you get past the Daubert standard?
Easily, Judge. Let's go to page 52. Ms. Klein asks, line 18. Let me make sure I'm on it. Yeah. Let me just make sure. I'm sorry. Page 54. She's asked on page 54, line 12. I would agree with you, so I'm asking in your opinion as an expert, to what degree of scientific certainty would you give your opinion, can you say? And his answer, line 22, 100%. Otherwise, I wouldn't present it. And he goes to...
Let me ask you this, because we've already had it, we're kind of bookending this trial with Daubert hearings, which is kind of fun. So let me ask you this. This is an issue you brought up with the state's expert. The defense had a problem with the state's expert related to her verification test, even though she disputed that term, with the APVP. And the court excluded it because she verified her own results. And that was the defense's argument to keep the state's expert from testifying to verification results. Other than his own work, how is this verifiable?
She testified in the deposition that he's been using shadows as part of his overall evaluation for the past 20-something years.
And he also testifies that he didn't get any training on it. That this is stuff he states that he learned on the job.
On the job, correct, but that doesn't eliminate the fact that that's something that's acceptable in the community. Judge, there's a handbook, the crime scene handbook. There's a book called Complete Crime Scene Investigations Handbook, which discusses shadows. That's written by Everett Baxter, Jr. There is Christopher Duncan wrote Advanced Crime Scene Photographs, which implicates the use of photographs
I'm sorry, say these again to me?
Okay, Christopher Duncan, Advanced Crime Scene Photographs, is the article that was published. Hold on, I have an actual journal entry. Give me 1 second, Judge.
Duncan, D-U-N-C-A-N?
D-U-N-C-A-N, first name Christopher. Okay? Let me find it, Judge. Give me 1 second. That's a peer review article that speaks to shadow matching, which is what's at issue here. There's Everett Baxter, Complete Crime Scene Investigation Handbook, which talks about shadow matching. There's even, Judge, they even had an an episode on forensic files. Forensic file episode 148. It's called Shadow of a Doubt, where they used shadows to make a determination. Listen, I think every crime scene reconstructionist takes a slew of factors in making a determination as to what goes on. For us to sit here and to think that when an incident occurs out of our visual perceptive ability, and there are shadows that are consistent with two people in a small area, that a crime scene reconstructionist or someone in that field can't look and evaluate the shadows. And here's the biggest issue here. He's testified with regards to shadows in court before. He's testified in 3 states and over, I think, 25 trials. And what he does is it's not just the shadows. He takes a culmination of everything together. And if you read the deposition